3, 2, 1.
Okay, good afternoon again. Now we continue our meeting. Please invite a candidate for the position of the judge of the High Anti-Corruption Court, Kimstachov Oleh Serhiyovych, into the room.
Задається питання щодо відповідності кандидата на посаду судді Вищого антикорупційного суду Kimstachov Oleh Serhiyovych
Kimstachov Oleh Serhiyovych with the criteria set out by Part 4 of Article 8 of the Law of Ukraine on the High Anti-Corruption Court. So we have present PCAE members, Robert Brunheisen, chair of the PCAE, Norman Aas, Mary K. Butler, remotely. Gabriele is not yet with us, right? Mr. Robert.
Gabriele is not present. Зрозуміло. John J.
Okay, understood. John J. O'Sullivan and Jessica Lott Thompson. Also, we have present HQCJ members Михайло Богоніс, Людмила Волкова, Віталій Гацелюк, Ярослав Дух, Роман Кадисюк, Олег Колюш, that is me, Ігор Кочнір, Руслан Мельник will join us in a couple of minutes, Олександр Омелян, Роман Сабодаш remotely, Руслан Сидорович, Сергій Чумак, and Галина Шевчук.
Зрозуміли вам склад комісії?
Do you understand the composition of the commission? Yes, the composition is clear. We are explaining your rights now. You have the right to request recusal of commission members, provided the records set out by the law, to submit motions and provide explanations upon permission of the chair to express your considerations and objections regarding the considered matters and to challenge decisions in instances set out by the law. I am informing you now that Kimstachov Oleh Serhiyovych has submitted a recusal request regarding Kolyush Oleh Leonidovich. It was registered today, and that's why, after the explanation of the composition of the commission and your rights, I would like to ask you, do you maintain your request? If yes, please, I will pass presiding rights regarding Helena, and we will clarify the grounds. Yes, I maintain my recusal request. Please consider it on the merits. Okay, understood. Now, Helena Shevchuk will preside over consideration of this issue. So, we have received a request regarding recusal. Please provide briefly your motivation for that. Briefly, in my recusal request, I specified and referred to two facts which, in my opinion, might cause doubts about impartiality of Commission member Kolyush Oleh. The first ground is that Commission member Kolyush is the judge of the High Anti-Corruption Court starting from 2019. Also work in the High Anti-Corruption Court in the court apparatus starting from 2019. In the law of Ukraine on the judiciary and status of judges, it is not directly stipulated the essence of the notion of facts of causing doubts about impartiality are not disclosed. That's why I referred to the provisions of the Criminal and Civil Procedure Codes of Ukraine, which stipulate that judges of the High Anti-Corruption Court cannot consider cases with respect to employees of the court apparatus, and not only judges. That's the first fact. And the second fact is that during the examination of dossier within the framework of competitions to the Court of Appeal in October of 2025, Commission member Oleh was the rapporteur regarding my candidacy, and during the conduct of the interview and the discussion of matters that were highlighted in the conclusion of the public integrity council during the provision of answers, Commission member Oleh at least twice specified that there was no need to disclose in more detailed information because some circumstances and facts were previously examined in other competition procedures. In connection with this, I believe that overall these facts might cause reasonable doubt about impartiality of Commission member Oleh. Okay, thank you. Mr. Robert, do you have any questions to the candidate regarding this matter?
I'm just thinking, because this is new for me. I'm just looking at my colleagues.
So do you believe that Oleg should recuse on all hack candidates, or only hack candidates that are judicial assistants, or only you?
I submitted the recusal request regarding Commission member Oleh from consideration of my candidacy. With respect to other participants who are judges of the High Corruption Court, as far as I know, the Commission has already considered that matter, and it was decided to recuse him only from consideration of one candidate, who is a judge of the High Corruption Court. And with respect to other candidates, the self-recusal request of Oleh was not satisfied.
Just that I understand correctly, because, and of course I don't know Ukrainian procedures about how this works. So, but what I understand is that you say is that first, that with Mr. Kodius, because he's a member of the HAC, is a reason to disqualify him. And that I don't immediately understand, because he's put in the commission here to select people in the HAC. He has another job now. So why that disqualifies him, I don't exactly understand. And the second thing is that I understand that you say that during the interview, he said, and I don't know whether this is true or not, but that he wished to rely on earlier decisions. And that you find that his attitude during the interview was not positive towards you. Is that what you say? Because we have had an interview, I think, with all of us. We have been here before. And you issue a recusal against Mr. Kodius, and not against me or against anyone here. Can you explain why Mr. Kodius is the one who should recuse himself?
With respect to the latter statement of yours, I am asking for his recusal in connection with the expressions of Oleh during the competition to the Courts of Appeal in October of 2025, not during the special joint meeting in February of 2025. And with respect to the first circumstance, then I referred to provisions of the procedural legislation as an example that the legislation is pointing out that the judge of the High Corruption Court should not take part in the consideration of cases involving employees of this court. I specify that as a fact, as an objective criterion that might cause doubts about impartiality of Commission member among external observers.
Okay, but this is not a case. This is a job application. So why would he be, Mr. Kodius, be impartial, not impartial? Because he's a HAC judge. I don't understand that.
I understand that that is not a court case, that is a competition, but I'm pointing out that similarly to the procedural legislation, so that external observers do not have doubts that maybe Commission member Kolyosh might be interested or biased regarding my candidacy in connection with the fact that we work in the same court. And in connection with that, I've mentioned that fact.
Mary, questions? No? No. Back to you, please.
Добре, дякую.
Okay, thank
Прошу,
you.
можливо, у членів комісії ВКК.
Maybe commission members have questions. Yes, please. Mr. Chumak?
У мене питання.
Mr. Oleh, I have a question. Article 100 of the law of Ukraine on the judiciary status of judges gives two grounds when a commission member can be recused. That is, when there is a conflict of interest. As far as I understand, we do not have this circumstance here. No. Okay. And then we only have second possible ground. These are facts and circumstances that can cause doubts about the impartiality of the commission member. And you're referring to this particular ground, that commission member Kolyosh is biased about you. Right? I'm pointing out that there are circumstances which can cause doubt about impartiality. That's basically being biased. But being biased cannot emerge on its own. In my opinion, there should be some reasons for that. Please tell us, you work as assistant of the judge in the anti-corruption court. Yes. Judge of the Hague or appellate chamber? Judge of the Hague. Tell us, please, regarding your work in the anti-corruption court, maybe you had some conflicts with commission member Kolyosh. Maybe your judge has some conflicts with Kolyosh. So biased attitude should be based on something. It cannot just appear on its own. Mr. Serhiy, in my request, I'm specifying that I do not have a position that Commission member Kolyosh has a subjectively biased attitude towards me. I've mentioned that based on subjectivity, I do not have objections against Oleh's participation in the consideration of my candidacy. I'm referring only to the objective criteria, that the very fact of working in the same court can cause doubts among external observers. Okay, tell me please then, but you did not request his recusals during the previous competition to the Hague or during the competition for General Courts of Appeal, even though the situation has not changed since then, right? Do I understand it correctly? During previous competitions, I also informed that based on the subjectivity criteria, I did not have grounds to ask his recusal. And if the commission member or Kolyosh or other commission members had grounds for self-recusal based on the objectivity criterion, then that issue might be considered. This time, I've also mentioned actions and expressions during another competition that, in my opinion, might point out the lack of impartiality regarding my candidacy. Again, I will follow up on my question. Please tell us, regarding your work in the anti-corruption court, have you had any conflict, some negative communication instances or something like that? No, none. Oh, we did not know personally. We did not come across each other during the process of work. Thank you. Thank you. Maybe there are some other questions from commission members. If possible, I would like to clarify, because you requested the recusal because of expression during the competition. And since I was also a member of the panel conducting your interview, maybe you have some request to recuse me as well. These expressions were heard exclusively from Commission member Kolyosh, who was the rapporteur regarding my candidacy, and to other members of the panel did not say anything like that about me. If there are no other questions, Mr. Oleh, maybe you would like to express your opinion regarding that. Yes, thank you. As fairly pointed out by Mr. Oleh, during the work in The Hague, we have never come across, we have never had any relationship among ourselves, and no conflicts either. And that's really true. And there is no biased attitude from me towards the candidate. With respect to expression, then in the context of expressions, I do not remember specifically, but probably I was referring to the unified indicators of compliance of the judge with the criteria of integrity and professional ethics, according to which facts and circumstances which were established following the statutory procedure are not subject to the review. So back then, it was the Public Council of International Experts during the previous competition to The Hague, and maybe regarding that I said something, but there was no bias attitude towards the candidate in my expressions, and there can be none. And I do not feel any bias as of today. But if we are talking about that from the if we conduct the analysis from the perspective of subjectivity and objectivity criteria, and if the commission decides that it is necessary to recuse me, that's for you to decide, colleagues. Thank you. If there are no more questions, please let's move on to the closed mode of the discussion of this matter. Dear candidate, please leave us, and Oleh, please leave us as well, because he will not take part in the consideration of this matter.
3, 2, 1. Announcement to continue the session and the minutes decision of the Commission regarding this matter is being announced regarding to deny from the satisfaction of the motion of Oleh Kimstachov regarding recusal of the Commission member Oleh Serhiyovych because of the absence of grounds indicated by Part 1, Article 100 of the law of Ukraine on the judiciary and status of judges. We continue our session, and I give a floor to preside to Oleh Leonidovich. We continue the session, and we pay your attention that at the special joint meeting we do not consider any materials that are being submitted right now by the candidate if there was a chance for the candidate to submit those materials earlier, but the candidate or other persons failed to submit to the PCIe or the Commission. And if there is an initiative of at least 3 votes of the PCIe or the Commission upon the motion or application of the candidate, the decision could be made to attach such documents from the side of the candidate if at least we have 3 votes in favor from the side of the PCIe. And also would like to inform regarding obligations of the Commission and PCIe members regarding the interview and the procedure, and in front of the candidate he has a rule, and Mr. Kolish is rapporteur on this candidate, and that means that I am the rapporteur. So I'm moving to the report regarding this candidate. By decision of the HQCJ dated June 3, 2025, a competition was announced to fill 23 vacant positions of judges of the Hague and the appeals chambers of the Hague. Within the established time frame, Mr. Kimstachov applied to the Commission for admission to participate in the announced competition for the vacant position of a judge of the Hague as a person who meets the requirements of paragraph 1 of part 2 of Article 7 of the law of Ukraine on the High Anti-Corruption Court, and to conduct a qualification assessment to confirm his capacity to administer justice in the relevant court. By decision of the High Qualification Commission of Judges of Ukraine dated 16 September 2025, Mr. Kimstachov was admitted to the qualification of the assessment and competition. By decision of the Commission September 19, 2025, qualification assessment was appointed within the competition for vacant positions of judges of the Hague and appeals chamber of the relevant court. By decision of the Commission dated September 19, 2025, the qualification exam was scheduled as part of the competition, and the sequence of stages for its conduct was determined. The decision for High Qualification Commission of Judges of Ukraine of 4th February 2026 approved the overall results of the first stage, taking the qualification examination. Based on the results of the qualification exam, the candidate scored 352.62 points and was admitted to the second stage of the qualification assessment. Candidate's qualification. In 2007, Kimstachov graduated from the Yaroslav Mudry National Law Academy of Ukraine, received a full higher education in specialty jurisprudence, and obtained the qualification of a lawyer. In 2011, Kimstachov graduated from the Yaroslav Mudry National Academy of Ukraine and received a full higher education in the specialty jurisprudence and obtained the qualification of a lawyer. The candidate doesn't have a scientific degree or academic title. Professional activity of the candidate. In 2007 to 2009, he worked as a legal advisor at Pecheniska LLC. In 2009-2010, he worked as a chief special legal advisor at Pecheniska District Administration of the Kharkiv region. From 2012 to 2018, he worked as a judge at the Uman City District Court of Cherkasy region. By decision of the High Council of Justice dated October 23, 2018, he was dismissed from the position of judge upon his own request. In 2018, he worked as the head of the department for the implementation of youth policy and the promotion of a healthy lifestyle at the Kharkiv Regional Youth Center. From September 3, 2019 to the present, he has been an assistant judge of the patronage service of the Hague. Mr. Kimstachov also received a certificate of the right to practice law issued on June 3, 2019. The right to practice law was suspended in accordance with paragraph 1 of part 1 of Article 31 of the law of Ukraine on the bar and the practice of law from 22nd October 2019. Mr. Kimstachov has a first degree proficiency in the state language. The candidate has submitted declarations of family ties, integrity declarations, and declaration of a person authorized to perform the functions of the state or local self-government authorities. During the competition, the Commission sent requests to a range of public authorities and received replies. Also, candidate participated in the competition for the vacant position of judge in the Hague, announced on 2nd August 2018. And he has also participated in the competition for position of a vacant position of a judge at the appellate courts, announced on 14th September 2023. And by the decision of the Commission, it was decided that during special checks, there was no information received that he is compliant. And even more to say, during the qualification assessment, Mr. Kimstachov has got 436.39 points to work, and it was recognized that Oleh Kimstachov as having failed to confirm his ability to administer justice in the General Courts of Appeal. That's all from the rapporteur. Have we mentioned everything? Did I omit anything? No, everything is correct. Thank you. And Mr. Robert, that's all from my side. Over to you.
Thank you, Mr. Kolius. Yeah, my name is Robert Broekhuizen. You know that we have seen each other before, and I'm also the rapporteur in your case. And I've looked at your data again, and I've noted that in the file there is a EIC decision of 6 March 2018 in your qualification assessment. And I've also seen that then proceedings for alleged unethical conduct were started, and this has as a result that you stepped down from being a judge, or resigned, or was dismissed. I don't know exactly how that went. And you, in that moment, you also applied to be try to become a Hague judge. And I've noted that 11th of April 2019, the HQCJ in that format then terminated your. In 11th April 2019, the HQCJ terminated your qualification assessment because you stepped down. The 21st January of 2019, your competition for the Hague was terminated because of reasonable doubts. You appealed this decision, and you lost this in the courts in a judgment of 16 October 2020. Then you applied again to become a Hague judge. We have seen you before and had an interview with you. And we filed a decision was filed 19th of February 2025, where it was found that you were unsuitable to be a judge in The Hague. And you appealed this again, and there's a decision of the Supreme Court dated 5 February 2026, which I've seen, which is quite widely reasoned. And in the meantime, you also applied to become a judge in the appellate courts, and there was a negative decision 23 of October 2025. So what I see is that this is the third time, I guess, that you applied to become a Hague judge. And you have quite a few, let's say, negative decisions against you. And if I summarize it, there are issues regarding the violation of integrity. There was something about payment in crypto, and some other issues. And when I read your answers to the questions we raised. In your answer to our questionnaire, you say, there are no facts or circumstances in my life that could raise concerns about my compliance with the criteria of integrity and professional ethics during my participation in the current competition for the vacant position of judges of the High Anti-Corruption Court. And I just mentioned an enormous amount of negative decisions on your behalf. We had a conversation with you before. So can you please explain why you are here again and what has changed in the meantime and why we made mistakes in assessing your compliance? Because, I'm wondering why we do this all again.
Вмикайте мікрофон.
Please, your mic. So, within this competition, when answering the questions, I stated the fact that I participated in the questionnaire, and that information is in the questionnaire. I participated in the previous competitions for the position of the Hague judge and the judge of an appellate court of appeals, and each of those was a singular, unique procedure, and the body leading the competition needs to decide on the eligibility of the candidate. And because each procedure is a unique one, considerable amount of time has passed since the previous competition, and I have been mentioning the same circumstances that I mentioned earlier, those of 2014 and 2016.
Оцінка моїй відповідності вимогам закону до кандидата на суддю Вищого антикорупційного суду з урахуванням тих обставин, які існують на сьогодні.
There's no translation with me.
Забезпечте переклад. Щось немає.
Hello? You have translation? No. No translation. Hello?
Can you hear interpreter speaking right now?
Test.
Yes.
Test.
Yeah, I can hear you now. Can you say something?
Testing.
1, 2, 3. Can you hear interpreter speaking right now?
Yes.
So
Okay, thank you.
So maybe, Mr. Kimstachov, you can go back a bit in your answer.
Моя позиція щодо участі в цьому
So,
конкурсі.
my position regarding
my
participation in this competition
Why I'm participating in the competition is because each procedure is a unique one, and each competition checks whether the candidate is eligible for a particular competition. This is why I decided to apply yet another time. And I left it to your discretion to study the circumstances that prevented me from being appointed to the position of a Hague judge.
Thank you for this. The point is that I have in front of me a decision of the Supreme Court of, just a few days ago. It's 5 February 2026. And there it says, summarizing the above, the Supreme Court, based on the scope of the stated claims, a systematic analysis of the cited provisions of the law and the evidence available in the case materials concluded that the stated administrative claim was unfounded and there were no grounds for its satisfaction. And that means that very recently the Supreme Court said that on basis of your earlier applications to become a judge in The Hague and your, let's say, the difficulties you have with this, which you explained to the Supreme Court and which were handled by the Supreme Court and were motivated in the decision of the Supreme Court. Supreme Court says, well, no, Mr. Kimstachov, he cannot be a high judge. And this is a recent decision of a few weeks ago. And so you must explain to me why the Supreme Court, in his ruling, made a mistake, or why the PCIe, reading this, should not look at the decision of the Supreme Court and take this as the basis of the decision making. Or do I say something incorrect, or is it different? Please explain.
Я вважаю необхідним звернути увагу на те,
So it's important to note that as of today, the decision of the Cassation Administration Court is valid, and there is still time for submitting complaint until March. This is one thing. And second thing, the court does not provide an evaluation of the candidate. They only evaluate the circumstances stated by them, and they state whether their acts were legal or not. And my activities as a claimant were of legal character, and there are no grounds for for a waiver. And the decision of the High Anti-Corruption Court 2025 and the decision of the cassation courts, they are there, but the decision of the Cassation Administration Court still can be challenged, and it's not incorrect for us, inappropriate to talk about the decision of the court that has not entered into effect. So the correction, that decision has not yet entered into effect yet. And they cannot be used as reference for evaluation of my candidacy.
So you say that I should not be referring to the Supreme Court decision. Is that correct?
So
that decision has not yet entered into effect. So it would be inappropriate to refer to it.
Okay. But what you say is that by this simple lapse of time, I understand, if I understand you correctly, there are no issues with integrity or professional competence anymore. One of the issues that we have discussed earlier, and is also, let's say, in all those decisions I have mentioned, is the fact that you ruled in a dispute where a fellow judge was a party and you granted the claim of the fellow judge in full. And what has changed that we should not rely on this?
I'm sorry, I didn't quite understand. There may be a need to reword it. And please use the mic. I didn't understand the question because the interpreter didn't quite understand the question. Could you please repeat?
What I tried to say is that in the file, there's an issue regarding that you acted as a judge in a dispute where a fellow colleague judge was a party, and that you fulfilled the claim of your fellow judge and granted the claim of your fellow judge in full. And my question is, what has changed that we cannot rely on this fact that appears from the files and all those decisions?
Проекту судову справу йде мова. З приводу цієї ситуації
Regarding this situation,
в письмових відповідях зазначено.
in my written answers, I stated,
І взагалі, і щодо цієї справи, щодо інших судових справ, які згадувалися.
regarding this case and other
рішенні спеціального спільного засідання.
court cases,
Що так, я прийняв певні рішення чи
yes, I indeed, I took some decisions as a judge, and I cannot go back in the past and redo it, but my professional experience and as a candidate to this position gives me the possibility to know how to act in the future. So I'm learning from the past experiences, and I stated these circumstances because they need to be taken into account as of today, and also the lapse time since that case, and the fact that no rights have been violated, neither the rights of the child nor the rights of the parents. And we, as the district court, we did our best to give the defendant the possibility to provide answers, and there were no appeal. So I believe these circumstances need to be taken into consideration. And in my answers, I stated my vision of how the judge could handle a situation when the case lacks information about the profession of the party, how the judge can learn that the other party is a judge or other legal specialist. And it also depends on the circumstances of the case, whether it is obligatory to know that, whether the party is the judge that had considered that case previously, and then that case needs to be transferred to the police to check the legal character of the case. And please speak in the stronger voice for it to be audible in the broadcast. And I ended my answer.
Yes, the other issue that was discussed before, and it's also in the decisions, is a gift from your mother that was gifted in crypto, and the payment of the gift in crypto was made by your brother. You will recall this. And also on this subject, decisions were made, and decisions were published. This is not so long ago. It is only it's November 2023. So it's quite reasonably recent. And also in that respect, several decisions are in place where it's alleged that with this gifts something is wrong. And what's wrong with the decisions on this, and why was this not, let's say, looked at properly by the HQCJ and the PCIe last time? And why do we have to look at it differently? Because passing of time is not going to work here, not so long ago.
приводу до мене
So
поставлено
regarding,
запитання приводу обставин.
you're asking about the circumstances of how I received the gift from my mother in crypto
Наданих пояснень щодо фактично механізму,
and
як такий подарунок відбувся.
you're asking me to explain how she managed to give me that. So it is, if my understanding is correct, my understanding of the question is correct, then my explanation that I submitted in this competition, in the previous competition, contained some terms that could be translated inappropriately, other than in the sense that I intended them, I had intended. So I state that I declared that gift in non-material form as a gift from my mother, and I evaluated this gift. I stated the value of this gift in hryvnia. So this gift is in crypto, and that is stated in the declaration in the section of non-material assets. And as a non-material asset, all the transactions are reflected in the blockchain for all cryptocurrencies. And in my profile as of 2023, that information about the transactions in the blockchain could not be changed and overruled. And all of the information was comprehensively declared, stated in the declaration. Then the wording received a gift from mother. And when I use this wording, that I meant that there was an agreement of gifting, and the parties to that agreement was myself and my mother. And my mother was supposed to give me that gift. But in fact, she couldn't do that because she wasn't a user of cryptocurrencies. And in my explanation, I said that she had legal relations with another son of hers, Serhiy, a brother of mine, and they did not conclude any agreement in writing. They are relatives and they trust each other, and therefore they agreed on this verbally. And this is not natural thing in family relations. And the same applies when my brother lent $1,000 to $1,000 from my parents and then gave them back. So in 2016, $6,500 was lent by my mother to my brother to buy a car. And in April 2016, he bought that car. And further on, in December 2020, approximately, my mother transferred to my brother $10,000. This money was used by him to buy cryptocurrency, understanding that it could also bring profit to our mother. In 2023, my mother decided that she wanted to give me $15,000 because of my marriage, my wedding, so that we could buy an apartment. And she told me about that intention and to my brother Serhiy too. And she asked Serhiy to either take that money and from the crypto and transform it into physical asset, and then or leave it in crypto or whichever I preferred. And my brother said that he would transfer that gift to my mother in crypto. He used his crypto wallet and transferred that sum to my crypto wallet, and that was how the transaction happened. And I added all the details of that transaction in my declaration.
De facto, that was a gift that I received from my brother rather than from my mother. But I would like to mention the following. The civil law of Ukraine envisages that the parties are free in concluding agreements between them, defining the conditions of those agreements, if it doesn't violate mandatory requirements of legislation. In this case, there was a situation when the agreement was concluded between me and the mother regarding this gift at the amount of $15,000. And there was also certain legal relations related to a debt taken between the mother and Serhiy. So the fact that my mother was not physically in Ukraine and is not physically in Ukraine. So she was in Uzbekistan Republic at her parents' house and she's still there. So in 2023, she was unable to come physically to take this money from the brother and then give this money to me. So it's one of the options. It's a legal one. And another option, when Serhiy, as a debtor who took debt from his mom in order to pay off money to her, he could give this money to me as a person who was authorized by the mother as one allowed to receive this money. And I have informed the Commission and international experts that all information that was reflected in my replies as back as of February 2025 and now regarding the original funds of and the mechanism how transactions were done, that's trustworthy information. And I was frank in my efforts to provide as much information as possible along with underlying documents regarding the original funds of savings of my mother and its transfer to Serhiy and then back to me. Thank you.
The point is, Mr. Kimstachov, that we have heard this explanation before. And we thought about it and we have taken a decision on it. And the question I had for you is, what is changed after last time in February 2025 when we discussed exactly the same transaction with the same facts?
The circumstances under which fulfillment of the gift agreement and transfer funds happened, and the loan, everything in the past. So, as of now, I've provided you with my perception, my understanding, my opinion. And I also corroborated it with provisions of the Civil Code of Ukraine that all actions from my side, my mother and my brother, were fully aligned with provisions of the law and documents that were provided for consideration of the Commission's PCA include information both regarding the regional funds and the volume of those funds. And I have informed already that my mother and my brother, they had their own relations based on trust, and they acted as private persons.
You explained it already. I have no further questions. I'm looking at my colleagues. Mary? No? No. We are finished with our questioning, Mr. Chair. So over to you.
Членів громадської ради міжнародних експертів більше запитань немає.
As there are no other questions from the PCIe members, I will ask a few questions and then I will ask my colleagues whether they have also questions to you. So the first question, in your explanations to the questions of the PCIe members regarding receipt of a gift from your mother in the amount of $15,000 USD dollars, you have mentioned that through your mother, your brother gave $6,500 to purchase a vehicle in 2016 and $10,000 to invest into cryptocurrency during the period from 2020 to 2021. Also, in 2016, your mother purchased an apartment at the amount of 100,000 hryvnia, which was equal to 3,913 USD dollars approximately. Please provide explanation regarding the origin of funds to purchase this apartment by your mother. Regarding the conclusion of sale and purchase agreement for an apartment back in 2016, so with Mykola Dmitrovich, that's an individual person, I would like to inform you the following. At the candidate's dossier files, I provided my replies and supported it with the following documents: that my mother and that person, they have known each other since 2013, and in 2014 she provided help to this person in the format of taking care after this person. They were in communication. This person was single, and because of her health status, she required certain support from an external individual, and my mom provided her with that. Then this person has issued the last will, and all her registered property was indicated in that last will to be transferred to my mother after the death of that person. The sale and purchase agreement was concluded in 2016, in a year after the last will was drafted. As I have explained, I was not a member or party of that sale and purchase agreement. I was not engaged in the conclusion of that sale and purchase agreement, and I can only provide explanations based on words of my mother regarding the situation. As my mother explained me, back in 2016, given the health status of that person, and given the fact that on the territory of the Russian Federation, that person had relatives there, so they agreed that they are going to conclude the sales and purchase agreement regarding this apartment located in Kharkiv. It was considered by my mother as a guarantee that this person who was further under her care after the conclusion of the agreement, but that agreement was a guarantee for her that this person would not change her mind afterwards and would not transfer this apartment or property to other persons, including her relatives, or in order to avoid any potential disputes between my mother and relatives of that person. That agreement also confirmed that my mother had been already taken care after this person for 2 years as of the moment of conclusion of that agreement, and had been providing her support, and that's it was also a ground for defining that price. So the condition of that apartment also was outdated, everything was old, no repairs were done, an elderly person had lived there. So for my mother it was almost impossible to live there without carrying out any capital repairs works. It was also a ground for such a price. My mother has provided also me with an information. As of that moment, it was approximately $4,000. That's regarding the funds for that apartment. So $4,000 at that moment. She had already savings at such amount, considering the fact that in April 2016, $6,500 she had also transferred to your son. So at this weekend, I have just had a call with her discussing this issue because I saw at the PCIe members this question regarding the apartment located in Kharkiv. So she explained to me that a part of those funds and the other sources of funds that I provided to you last year, so those sources of funds that were related to confirm the original funds regarding the gift. So she also confirmed that other funds were used. So she informed me that in 2013, her parents from Uzbekistan transferred to her 2,000 USD and a part of other savings that she had in cash as of the moment of death of my father back in 2012, and I mentioned that that was the savings in the amount of $3,000. My mother had also some money at the bank accounts as of February 2012, and that amount was roughly €2,000. And at my dad's account at Privatbank, it was also roughly $2,000 at one of his bank account at Privatbank. So it means that at that moment she had enough funds to conclude an agreement under such a price. And she also mentioned that anyway, those funds were used to help this person. They were further spent on her treatment, on some rehabilitation, sanatorium centers, medical drugs, so on. Okay, thank you. Next question, and please become more concise in your replies. According to the declaration of a person obliged to carry out local government authorities for 2023, you mentioned the selling of cryptocurrency to private persons. Please explain. Have you paid any taxes on income received from such alienation of cryptocurrency? Individual persons' taxes were not paid by me regarding this alienation of crypto assets because neither at that moment nor now legislation envisages a mechanism how such income shall be calculated. I mentioned that selling of that cryptocurrency was done under actual cheaper prices than the price of its purchase back in 2020 to 2021. So if we compare the investment price and the alienation price, we see that the alienation price was less than the investment price. So there was no profits at all from which I should have paid taxes. And at your explanations as to the questions of the PCA, you also mentioned on 28th December 2025 of a return to your brother of funds at the amount of $10,000. But at the same time, along with the document on confirmation of return of a debt, on that day you have returned $11,000. Please justify this discrepancy and explain it. The issue is that at that day, the return of funds took place. So in hryvnia through the bank transfer, and in USD, 10,000 were given in the USD currency. There were 4 bank transfers to his bank account in hryvnia. That's why I mentioned that total amount that is significant, and that's why I mentioned it as the fact of return of those funds, because it was a significant amount. But anyway, what you have explained.
У запитання 2.5.
At question 2.5 of international experts, we have the following question. Did you or your family members under term of legislation as family members in 2025 any expenses which exceed 151,400 hryvnia? If yes, provide any of such expenses and underlying documents. Answering this question, as $10,000 as of 28 December 2025 were equal to 419,000 hryvnia. I mentioned the return of the sum. The funds in hryvnia were not exceeding this amount of 151,000 hryvnia, and that's why I didn't mention that amount. But this information is available at written confirmation receipts. Thank you. I have no other questions. Sergey Yurievich, do you have questions? Thank you. Mr. Oleh, again. So, you have been a judge of the district court from 2012 to 2018 before you submitted your application for dismissal. Yes. So I have looked through your career path. It's quite, turmoilic and not in a positive way. But I would like to ask you the following question. Of course, if you have any wish to answer. So, on 23rd October 2018, during the qualification assessment regarding you and certain disciplinary proceedings against you, and the period of consideration of those proceedings was just a few weeks before it. On 11th of October 2018, you submitted an application for dismissal based on your own wish, and you were dismissed. Please explain the grounds for that dismissal. At that moment, you were challenging all those decisions regarding you, and just to give few details, so in chronological order how it happened, but before I give some details, I would like to hear from you. So you were a judge. Why you quitted the job? So, the decision on my dismissal from the position of a judge made in 2018 based on my own request. I would like to inform you the following. So, I would like to mention the chronology. So, I had administered justice since May 2012 to April 2018. So, during 5 years, when I had those powers of a judge. Then my powers of a judge terminated to administer justice, and I think in November 2018, the qualification assessment procedure for compliance with the position of a judge started. I participated in all procedures as those procedures were scheduled. I successfully completed the qualification exam. I took the psychological and moral qualities test. I had an interview with a psychologist, received conclusions based on that interview. And in March 2018, the interview with the interview on the dossier check was taken, and based on the results of that interview and study of that dossier, it was decided to terminate qualification examination and forward my files to HCJ to open proceedings against me. Disciplinary proceedings against me, and the relevant HCJ member who was assigned to consider my case, Mr. Oleh, please be concise. My question was regarding the grounds, your motives, because now you're applying for the position of a judge. You were a judge already, and you quitted the job. Now you want to have a job of a judge again. So please, your motives, concisely. because we will return back to the question of chronology. Okay, I will reduce my reply. So as of the moment, when I made a decision on this, to submit application for dismissal, I had not fulfilled my powers for 18 months, and I submitted my application for participation in the competition of a judge of the Hague, which was announced in August 2018, before the date of consideration of my admittance or denial to admit me to the participation in the competition by the panel. There was a decision made by the HJ to impose disciplinary sanction against me, and before the date of consideration of the fact of admitting me or not to the competition, my complaint regarding the disciplinary proceeding initiated by the HJ was not considered and was not scheduled for consideration. And according to the law on the status of judges, it was envisaged that judges who are subjected to disciplinary proceedings, they could participate in different competitions or could be transferred to other courts. Given the fact that I didn't have any powers of a judge, and if the check related to the termination of qualification assessment is finished, and I didn't know when this check should have been over, I decided to use this opportunity to participate in the competition for the position of the Hague judge. I decided that such an opportunity of such participation is more important for me rather than to try to be at the position of judge at the local court, because I didn't know when my powers will be returned back to me. That's in a nutshell, that's all. I didn't get your point. What actually was an obstacle for you not to participate in the Hague competition when you were a judge? But again, I wanted to mention that you were rejected in participation in the competition for the position of the Hague judge because at that moment you had existing disciplinary sanction over you and was still in force, and it's related to the decision as of 19 December 2018 you were brought to disciplinary liability for. So, roughly speaking, because for 1.5 months you failed to issue the full text of the court decision to the plaintiff, to the party, to the process. But in the text of the decision, it was mentioned that when they were deciding on the sanction, specifically severe reprimand with taking off your additional benefits, it was also mentioned that at that moment you had also one active disciplinary proceeding in the format of reprimand. That's why another disciplinary proceeding was imposed, resulted in the sanction of a severe reprimand. And so you were brought to disciplinary liability on 9th February 2016. Please tell what was about 2016 in 2-3 sentences.
I will allow myself a remark. As of September 2018, I did not have any sanctions, ongoing sanctions. And Oleg, so in the decision of VRP, there is the statement that there is an ongoing sanction and there is a reprimand as of February 2016. There is a High Council of Justice decision. Oleg, please. I'm asking about different thing. Could you please answer my question directly? Why was you sanctioned February 2016 for violating the time frame for considering administrative case? And after that, the High Council of Justice canceled that and closed the disciplinary proceeding. But back then, if we analyze the chronology, and we have talked about it earlier, a qualification test was suspended and you were supposed to take it, but it was suspended. And the reason why it was suspended by the decision of the Commission, decision is of 2018, and that story is a kind of nasty, because the chair of the court turned to Constitutional Court that you, together with other two judges, as of November 2017, you did not have a permission to enter her office. You closed the door, you locked the door, and in a very rude manner and using swear words, you try to decide the issue of yourselves going to a seminar in Chernivtsi. And among those three judges, so those three judges, there were some who actually did not allow her to leave the office. And actually, it ended up in calling the police to the court facilities in order to free the chair of the court from her office. And this is why she submitted a complaint, a claim with the High Court of Justice. After that, a proceeding is started regarding the violation of the term of consideration of an administrative case. And then in a few days, you are sanctioned. And in September, the Council of Justice opens a new investigation into the fact that so they start a new investigation, and the chair of the court is a claimant there. And it is not allowed to consider the case arising from the internal affairs of the court in the same court. And so I'm just giving you the chronology. So you still have an ongoing disciplinary sanction back then in September. Then in late September, a new investigation opens against you. And then that story with the chair of the court. And then in 2 weeks, you submit an application, your resignation. You submit your resignation. So you also stated that you could operate in the hack, not only as a judge, but in a different position. But given all those proceedings and cases, wasn't your wish to resign related to your previous disciplinary record? And you also stated that you could operate in the hack other than as a judge. So regarding my resignation, my motives to resign, and my motivation to participate in this competition, in fact, without the competition in 2018, I wouldn't have resigned from my position of the judge in the local court. And I can see that international experts were given materials related to the competition to the appellate court and circumstances considered by the public counsel. I actually explained very much in detail the reason behind my resignation, and I could assure you that I didn't need to resign from the position of the local judge in the local court.
Зауважу про те, що дисциплінарні справа, яка була відкрита за
And that happened independently of the disciplinary proceedings. And the circumstances that pushed me to resign lay beyond disciplinary proceedings that were initiated in September 2019. And another thing, a few disciplinary proceedings, the fact that a few disciplinary proceedings pushed me to resign actually is not grounded. The statement like this is not grounded. And the High Council of Justice had numerous complaints against me. But by September 2018, each of those complaints was communicated by me, and I explained my position and provided the corresponding documents. And I did not mean to evade disciplinary liability. And in late September 2018, you can actually check that I communicated with the disciplinary chamber when they closed the case because of my resignation. I challenged that decision. I challenged the motives of that closure. I asked the High Council of Justice to consider that claim. Thank you so much for your answer. So, the competition to the Hague and impossibility to participate in them given my disciplinary sanction pushed me to resign. If it weren't for that, I would have stayed. What is the link between your work in the Uman court and your participation for the Hague position? So in September 18th, you were charged. And given the sanction, then you resign, and then you could not apply for participation in the Hague competition because you still had an ongoing sanction. So what is the link? I don't really understand it. The link between your work as a judge at Uman court and the denial that you got from the Hague to participate in the competition. So what is the direct and logical link? And if you could please be brief. So, I wish to be a judge and exercise justice. I don't know about the results of the qualification test. It was suspended in March 2018, and in October 2018, the previous check was still being carried out, but there was no conclusion made whether disciplinary case should be opened. And my resignation removed barriers for me to participate in the competition for the Hague position, and I, at the same time, was challenging the decision of the disciplinary chamber because I believed that it violated the law of Ukraine on judges and justice, and all the factual circumstances were not taken into consideration when taking the decision by the disciplinary chamber. Thank you for your answer. Colleagues, No more questions?
Немає.
No more
Олег Сергійович,
questions.
тоді надається вам межа
Then,
однієї
Oleg,
хвилини,
you have 1
можливість
minute
зазначити про те, що могли
to
зазначити до цього.
state something you haven't stated yet. Thank you for listening to me. I have been as sincere as I could with the public Council of International Experts and tried to give you comprehensive answers. Thank you. Thank you for your participation. The interview is complete, and stay well,